God save the Commonwealth of Massachusetts. This court is now open. Please be seated.
Good morning. Welcome to the March 7th, 2023 sitting of the Massachusetts Appeals Court. I am thrilled to introduce our panel today. Sitting to my right is Justice Kenneth Desmond. To my left, Justice Paul Smyth, and I'm Justice Eric Neyman. We will be your panel for all 6 cases this morning. Usual appeals court rules are in effect, so each side will have 15 minutes to present argument. There will be no rebuttal. I can assure you that this panel is well versed in the facts of the case, so we'd urge you to cut to the heart of your argument and make your best arguments first. Anything else, Justice Smyth, Justice Desmond? Wonderful. We will call our first case, docket 22P965, Commonwealth versus AGYEAH. We will hear first from Attorney Dahlberg.
Good morning and thank you. Nancy Dahlberg on behalf of Sylvester AGYEAH. Justice was not done in 2 ways in this case. There's a lot of information here. Today, I would like to focus on the ineffective assistance of counsel received by Mr. AGYEAH when his lawyer failed to provide him with required immigration information that would have enabled him to intelligently and knowingly exercise his right to accept or reject the Commonwealth's plea offer. And if there's time after that, or questions, of course, I will proceed to the second area of ways in which justice was not done. As the court knows, the Commonwealth offered to dismiss the charge of resisting arrest and to accept findings of responsibility on decriminalized charges of disorderly conduct and disturbing the peace in this case.
Is there any indication in the record as to why your client did not accept that offer?
He didn't know the immigration consequences, Your Honor. That's in his affidavit.
Let's assume that he didn't. Even without knowing those consequences, why wouldn't he take that deal?
Without knowing the consequences, if the consequences were that they were negative immigration consequences, then going to trial makes sense. If he knew, as he indicated in his affidavit, and which the Commonwealth never disputed, and in fact, the Commonwealth conceded below that the attorney had given constitutionally deficient advice. They've tried to walk that back in their brief, but the concession has been made. It's really too late. That if he didn't know, if he had been told no immigration consequences, it would have been easy for him, and he indicated that in his affidavit. If there were immigration consequences and he's trying to get his family here, his wife and children, and he would otherwise be eligible as a permanent resident to apply, then it makes sense to go to trial, Your Honor.
He was told by his attorney, I believe, that there may be immigration consequences if there's a conviction, my understanding.
So his trial attorney, who was a bar advocate and had access to the Immigration Impact Unit of CPCS.
Didn't go to the Immigration Impact Unit.
He didn't.
He
So
told
he
him
said,
that my understanding is he said that there could be immigration consequences. You should consult an immigration lawyer.
Yes.
My understanding is further that he did consult an immigration lawyer who advised that a conviction would likely or possibly involve consequences, and I think the consequence would be a 5-year delay in the naturalization application process. Is that correct?
Yes, so about the time at arraignment, even though he had a bar advocate and so he was an indigent client, he did get advice, of course, which costs funds, but he got advice that a conviction could have that. So a year later, the Commonwealth offers a plea deal, a plea bargain at the time of trial.
Which did not involve a conviction.
I'm sorry, I didn't hear that.
Which did not involve a conviction.
Which he was told dismissal of resisting arrest and decriminalized charges. And, you know, he did not know what that meant. He did not understand what that meant. And his attorney, his trial attorney, was obligated to tell him that there was a likely 5-year setback. Well, he was obligated to tell him 2 things. The plea offer would have had no consequences, Mr. AGYEAH. On the other hand, you would face this possible or a version of what you were told a year ago. What he wasn't told, and what's crucial in this case, is that there were no consequences. And that is required.
So, first, do we know for sure that resisting arrest is a crime against moral turpitude? Do we know for sure of that?
What the affidavit of the Immigration Impact Unit has indicated is that it's likely to be
We know-
treated.
So we don't know for sure.
Well, what we know is the affidavit of Dan Harrington's, he,
I read his affidavit, but
yes.
can you point to some place in the record that tells me for sure that it's a crime against moral turpitude?
There's no case law on that, so I can't tell you that. What I can tell you is that it is treated as such by the immigration authorities of Massachusetts, where Dan Harrington practices, that the law indicates...
That was his experience. That was Dan Harrington's experience.
Yes,
right?
and, well, he's been practicing immigration law for decades. The issue of moral turpitude, there's many issues in which it's not defined. In fact, I think Balthazar talks about that. It's a question of, how, on one hand, it's likely to be treated that way under the law, and in fact, it is treated that way, according to the affidavits that we gave to the court, versus no immigration consequences.
Yeah, but we don't know for sure. And so, do we know for sure that he would have had to delay 5 years before applying for citizenship? Do we know
I would
that?
say yes, because,
What do we point to in the record to say for that, for sure?
so the question, Your Honor, is, was there a reasonable probability that the outcome of after trial would have been worse than the plea? There's no question that the plea was offered, that the judge would have accepted it, and that Mr. AGYEAH would have accepted it as well, if he'd been informed. And that's the question. Was there a reasonable probability that it was worse after trial than the plea? He indicated he would have taken it if he was told it was likely that he would face this probability. An experienced immigration attorney has told us that is what happens. And he has indicated that, yes, he would not have taken that risk. The risk he did take in going to trial was because he didn't know. Does that answer your question, I hope?
Yeah, it's
Yes,
it
all right,
answers
thank
my
you.
question.
So in terms of, so the outcome is that he, you know, a 5-year waiting period till the end of probation is May 2025. He otherwise would have been able to apply for citizenship in June of 2018. He, as the judge indicated.
Is there any indication in the record that he did apply for citizenship and had an adverse consequence?
That is not required, Your Honor. I think.
I understand it's not required, I'm just asking you.
Oh, no, he couldn't, really truly wouldn't been able to apply. There's a statutory bar, and that is Mr. Harrington's experience, and it's also the way that the case law is indicated in the...
Was the judge required to accept Attorney Harrington's affidavit? And the reason I ask is, he doesn't cite any case law. He could have attached something to the affidavit, for example, some dockets from the immigration court or some indication showing that in such circumstances, such negative consequences followed or were attached to a resisting arrest conviction.
Well, Your
That
Honor,
might have been more persuasive to the judge. I understand perhaps your argument is he didn't have to.
So the Commonwealth, in its, as I said, the Commonwealth conceded constitutionally deficient advice, and then it argued that prejudice wasn't shown because Mr. AGYEAH didn't provide proof that he had applied for citizenship and been rejected for that reason. That is not the standard. It's actually an error of law, and it was adopted by the trial court. That's the only, he said, for the reasons stated in the Commonwealth's memorandum. So, but that said,
Well, actually, the judge stated something a little different than that.
I have it here, Your Honor. For the reasons set forth in the
What
Commonwealth...
page are you on? I'm sorry.
Sure.
Are you on RA 247?
I may, So if I can read from his statement, for the reasons set forth in the Commonwealth's memorandum, trial counsel's failure to advise on immigration consequences did not constitute ineffective assistance. The Commonwealth conceded prong 1.
Well, but the judge made an independent determination. In the paragraph above that, the court is not convinced that the defendant's counsel's performance at trial fell measurably that below which might be expected from an ordinary fallible lawyer. So the judge, as he was obligated to do, conducted an independent examination and actually found that neither prong of Safarian was met.
Well, Your Honor, well, maybe there's a lack of clarity here, but I would say that he's making a general statement. There were many other issues in this case, and I will try to get to them, but here, it's for the reasons set forth in the Commonwealth's memorandum. The Commonwealth conceded prong one very specifically. So I have to say that this general statement above, I think is a general statement as to the motion for a new trial and not as to that issue. I would have to say that for the reasons stated in the Commonwealth memorandum has all to do with prejudice, and the standard that the Commonwealth invokes there seems to arise from Chapter 278, 29D, where alien warnings are given, and not in this kind of case, because we're really talking about information, and it could be other kinds of information, but information given to defendants so they can make a choice between a plea. Yeah.
I know you want to get to
no.
some of the meat of your argument, but how much does your case hinge on trial counsel's obligation here? And the reason I ask is I think our case law recognizes two separate situations. One in which immigration consequences are clear, in which case trial counsel is obligated to give more clear, more specific advice. In situations where the consequences are not clear, in which case the obligation, as I understand it under the case law, is to tell your client there could be adverse immigration consequences and go no further, essentially.
So I would say that the case law requires the attorney to give specific advice so that the defendant can make an intelligent plea. In this case, immigration consequences were implicated, and the question is, were there immigration consequences from the plea?
My understanding is there's a difference between when immigration consequences are clear or likely and when it is less clear. Am I incorrect in my understanding of the case law?
No, you're not incorrect, Your Honor. There are, most of those cases talk about when someone's making a plea and were they given enough information about deportation, is it likely or not likely. In this case, the situation was clear. There were no consequences to the plea, and that's what Mr. AGYEAH was not told. And that is something that Mr. Stanton could have easily have found out. Lavrenko and Marinho both mentioned CPCS as providing this information. People are available on an urgent basis.
So your argument is, even though he was advised that a conviction would have potential consequences, he didn't know that the plea deal where he received a dismissal and decriminalization of the other two counts did not constitute a conviction?
Yes, and would have no consequences. You know, there are other kinds of consequences. There's continuance without a finding, and one, you know, even Judge Pellegrini, I think, asked at the hearing, would something or other have had consequences? It's not going to be clear. It's certainly not going to be clear to someone with no involvement in the criminal justice system who's from another country. I'm sorry, Your Honor.
That's okay. Why wouldn't he take the deal?
I'm sorry.
Why wouldn't he take the deal?
Because he didn't know what consequences it would have for him, and
So he thought that there might be some consequences by having the case dismissed and decriminalizing the other two offenses?
Yes, you know, honestly, decriminalization was new to me since I was a trial lawyer. Yes, he didn't know, because otherwise, I think everyone was very puzzled, because this would have been a good outcome for him. And even at the hearing, the judge was trying to see if we could make some arrangement.
So his counsel advises him to seek further counsel on this issue, and he does, right?
A year before he goes to a lawyer, and this is what he's told. Could be 5 years from a conviction.
And so with that information, do we know whether or not he had any additional discussion with his trial counsel?
The trial lawyer offered no other advice. I mean, they were certainly there on the day of trial. Yes. I mean, his lawyer continued to represent him. He gave him no advice. We have 2 uncontested affidavits from Mr. Stanton on this issue. Would you like me to go on briefly? I have 1 minute. Okay. This was a real contest of credibility between the members of the Worcester Police and Mr. AGYEAH, wildly differing testimony, and Mr. AGYEAH actually, his own testimony indicated that he was a victim of unsanctioned use of force and racially based police conduct. And there were a number of issues about the Mr. Stanton's performance that certainly raised substantial issues requiring an evidentiary hearing. I'm not going to give you, I'll use one example, failure to introduce information about injuries, which was, again, a wildly divergent topic. Mr. AGYEAH indicates that the police very actively injured him, including the inappropriate use of handcuffs and failure to double lock them. The police disagreed, but there was the medical records which he had, the photographs which he knew about, the questions he asked himself of I don't want to take my time, of the police just actually damaged Mr. AGYEAH's case. If there are no further questions, okay, I will, of course.
Thank you, Attorney Dolberg.
Thank you.
And I would note for the record the very comprehensive briefing and work that you did both here and at the trial level. Thank you.
Good morning, Your Honors. May it please the Court. Nathaniel Bodwin for the Commonwealth. I do want to say I don't mean to be disrespectful. I am using cough drops today. I'm just getting over a sore throat. The judge properly denied the motion for a new trial. It was not an abuse of discretion to do so, and his decision to deny it was not outside the range of reasonable alternatives. He was correct in finding that the defendant did not satisfy either prong of Safarian. What his own lawyer said was—
You conceded the first prong before the trial judge, before the plea judge.
That is correct, Your Honor. And
what authority allows you to reverse course now?
Well, now this is an appeal of the judge's order, and the judge found that the defendant did not meet his burden to either one of those prongs. So I'm here to say that the judge was correct in disagreeing with the Commonwealth's concession at the time. And just to be clear, I was the attorney that did concede that. A colleague of mine wrote the brief, did, I would say, a better job researching the case law, and found these cases about when there is clear statutory language about a consequence from a conviction, like drug trafficking, like possession with intent to distribute. There are federal statutes that say the defendant shall be removed, or the defendant shall face certain consequences. As the defendant's own submissions indicate, there is no case law in this area. There is no federal statute saying that resisting arrest will cause a lawful permanent resident to be barred for 5 years from applying for citizenship.
So assume we agree with you, excuse me, I may need to borrow those cough drops, but
yeah.
Let's assume that we agree with you that the consequences here were not clear. What is the obligation on plea counsel, and what is your authority for whatever you're about to answer?
So when you look at Henry, when you look at Chalik and DeJesus, so I don't know if I'm pronouncing that right, Chlake, it says when the law is not straightforward, counsel need not do more than advise that a conviction may carry a risk of adverse consequences. And that is what the defendant's attorney said to him. These convictions, the direct quote, the convictions could have immigration consequences. The immigration attorney that he met with prior to trial said the defendant, quote, could be prevented from applying for U.S. citizenship for 5 years. So both really essentially saying the same thing. This could have consequences. The affidavit from the attorney from the Immigration Impact Unit doesn't say much more than that. It says that immigration officials could likely consider the conviction for resisting arrest to be a crime involving moral turpitude. But then she goes on to say that crimes involving moral turpitude are defined by case law. And then she goes on to say that there is no case law stating that resisting arrest is a crime involving moral turpitude. So that is why the judge was correct in finding that not only did he not satisfy the first prong, he didn't satisfy the second prong because he suffered no prejudice, even if this court finds that that plea counsel's advice or trial counsel's advice was not correct.
What about the language in Marino, repeatedly cited by Attorney Dahlberg, that states the defendant must demonstrate a reasonable probability the prosecution would have made an offer, which it did, that the defendant would have accepted it, and the court would have approved it?
I don't believe the defendant's affidavit says anything that plea counsel advised him not to take that plea deal. He was aware that going to trial carried the risk of a conviction, and that a conviction could lead to him being barred from applying for citizenship for 5 years.
Well, that begs Justice Desmond's question, then why would he not have accepted the plea if he understood that there would be, he would get a dismissal, he'd have 2 cases converted to civil, and there would be no adverse consequences? Unless he thought there would be immigration consequences, why would he reject that outstanding plea offer?
I would say the record is not clear as to why he did not accept that plea offer, and that includes no statement from the defendant that his lawyer told him not to take that plea deal.
Is the standard that the lawyer has to advise him not to take it? I don't think that's part of the standard.
The standard is that if it's clear, if it's straightforward that a conviction would have adverse consequences, then counsel must provide advice about those specific consequences. But in a scenario like this, where it's not clear, it's not straightforward, the only obligation on the part of counsel is to say, this conviction could have consequences.
Are the consequences or absence of consequences straightforward if the defendant accepted the plea deal? It's probably a poorly worded question. Do you understand what I'm asking?
What was it clear to the defendant that there would be no consequences if he took the plea deal?
What would be the immigration consequences of civil responsibility and dismissal? The answer seems clear that it would be none.
And I would not disagree with you, Your Honor. I don't see anything I'm not aware of anything that a decriminalized offense or that a civil infraction would, but, and I don't want to, and I'm not sure if the affidavits, well, I don't want to say something that I'm not too sure of. So I don't, forgot where I was going there.
Well,
I don't know if I answered your question.
let me ask you this. The judge at the hearing on at the motion hearing referenced something about a civil suit. Was a civil suit, and I'm only asking you if this is in the record. If it's not in the record, then don't answer this. Was there anything in the record indicating that the defendant had filed or intended to file a civil suit at the time of the plea?
I can tell you that it was definitely discussed the judge was aware of it.
It's in the record before us in the sense
Yes.
that there were discussions at the motion hearing.
Yes.
My question for you is, do we have any other information outside of that dialogue indicating whether or not the defendant had such a case outstanding?
I don't actually think there was in the record. I know it is before you. I know
It's not in the record, then
Yeah.
we can't consider it. Okay.
So for those reasons, I believe the judge correctly decided to deny the motion in terms of the whole immigration consequences issue. If you're on, yes, Your Honor.
At the end of the day, this is an ineffective assistance claim, right? After trial, it resulted in a split verdict.
Yes. 2 not guilties and 1 guilty.
Counsel for the defendant was the one who discovered the videos to begin with, is that right?
I believe so, yes, Your Honor.
He went out to the site, he saw the cameras, he made a subpoena to get the cameras, got the video. He's the one who uncovered the video. I think, turned out to be exhibit number 2, I think, is the one that everybody's
Yes.
focusing on. But all those videos, he had that. He hired an expert.
Yes. To actually enhance the video as well to make it more viewable.
told him he should go see another lawyer on immigration issues, and he did indeed go see another lawyer on immigration issues who gave him the very advice that he's complaining he didn't receive from trial counsel?
That's correct, Your Honor. If there are any questions on the defendant's other claims regarding failure to impeach, failure to bring in an expert, I can answer those questions for Your Honors, or I can rest on my brief.
Very rarely do we find ineffective assistance on failure to impeach.
It's a very difficult burden for a defendant to prove. And there was actually some impeachment of the officers on the stand by defense counsel.
There's a big issue regarding the medical records. Did he go right away to get medical attention?
No, he waited 3 weeks to go get medical attention for his injuries. The booking video indicates that he was asked if he wanted to have medical attention at that time. He said, we'll go in the morning, and instead he waited 3 weeks. And the defendant, on appeal is claiming these were severe lacerations, and I don't think it's credible to say that someone with severe lacerations would wait 3 weeks to seek medical attention for that.
Could the defendant have used excessive force? Could the defendant have resisted arrest while the officers also were using excessive force?
I think that the fact that the defendant was resisting and the fact that those officers discussed his resisting the entire time is an indication and would corroborate that he did receive some cuts on his wrists. Your question as to if they used excessive force, could he still be resisting? I'm certainly not aware of any. I don't believe there was excessive force here, but I can't speak to any specific case law on that issue.
I have one question about plea counsel's, or rather, trial counsel's affidavit. And I said plea counsel earlier, I should have said trial counsel. I'm at Record Appendix 54. But he states, for example, I did not introduce photographs of injuries to Mr. AGYEAH's wrists, although I knew that Mr. AGYEAH had injuries and had taken photographs of these injuries. I had no strategic purpose for doing so. He then states in the next paragraph, I had medical records concerning injuries to Mr. AGYEAH's wrists, but I did not introduce them at trial. I had no strategic purpose for doing so. How are we to read that language, I had no strategic purpose for doing so? Is he stating he had no strategic purpose for not introducing the photographs, or had no strategic purpose for introducing the photographs?
I interpret it as he had no strategic purpose in what he did with those photographs. And I would suggest if he tried to get those photographs in, dealing with the photographs, these are just photographs in the defendant's cell phone. There was no attempt to authenticate them. We don't know. We have an affidavit from the defendant saying, oh, these were on this date, it was on that date, but very, very unclear when these photographs were made. In terms of the medical records, as sort of what I was arguing earlier, Your Honor, I think had those medical records been introduced, I don't think they would have assisted the defendant. Because again, he waited 3 weeks to seek medical attention for them. And even if Your Honors find that counsel was ineffective for not introducing them at trial, the jury heard several times that, yes, when we place handcuffs on an individual, it's not the most comfortable thing. When someone is resisting arrest and officers are unable to lock the handcuffs in the appropriate way, that could cause some discomfort. That could potentially cause some injury. So introducing those medical records and introducing those photographs, I don't think undermined any of the evidence that the defendant resisted his arrest, which is what he was convicted for.
Well, perhaps with the assistance of expert testimony, it would have.
Well, the expert testimony proposed by the defendant on appeal is a retired Connecticut police officer, and he's suggesting had trial counsel introduce someone like Mr. Allard, someone who has had 35 years as a police officer, someone who's trained thousands of officers, someone like Mr. Allard would not be admitted to provide medical testimony, would not be allowed to say, Oh, those injuries, those were caused by handcuffs.
No, but
Those were caused.
he would be able to explain what protocols were violated ostensibly. He would be able to explain what causes such cuts if you put on handcuffs incorrectly, if you don't use the wrist lock, et cetera.
Well, that was the Commonwealth's argument in our opposition in the lower court, and looking at the judge's order, I believe he agreed with the Commonwealth's assessment on that the testimony, that the expert testimony proposed by the defendant in his motion for a new trial would not have been admissible.
Thank you very much. We appreciate your
Thank you, Your
arguments.
Honors.
Case is submitted. Our next case is 21P1110, Commonwealth versus Bergeron.
Good morning, may it please the court. My name is Brad Benyon. I'm here on behalf of the appellant, Mr. Bergeron.
Attorney Benyon, let me interrupt you. Housekeeping matter.
Sure.
By the way, nice to see you, counsel, by the way.
Good to be here, thank you.
The trial transcripts, you gave us portions of them, and not all of the transcripts, at least we don't have them. And so, for example, at Record Appendix page, I believe it's 156, sorry, this is volume 2 of the Record Appendix. So it's Record Appendix 2, 156, which is volume 3 of the transcript, page 28, where the victim's testimony begins. If you go to the next page, it's Record Appendix 157, but then it's volume 3, page 47. So we are missing pages 29 through 46 of the victim's testimony in volume 3. And your second issue, at least, certainly hinges in part on her testimony. So I don't know if that was intentional or an oversight. We're actually missing a lot of pages of the transcripts, and I think we're missing some transcripts altogether. I don't know if that was a choice that counsel made or not, but I can assure you we do not have the complete transcripts.
All right, I'll look into that. And
So if counsel wants to discuss afterwards and perhaps supplement the record, that would be a help to us.
sure.
It seems we have most of, or all of the cross, but we don't have the bulk of the direct.
Okay.
Thank you. And with that said, I just took 2 minutes of your time with that housekeeping matter, so I'll give you 2 extra minutes if needed.
So I guess we'll start with the motion for new trial that Attorney McNiff submitted. The heart of the issue is, as it was presented, that at the moment it was known at trial that there was more than one first complaint witness, or potentially. The argument is that counsel should have, and it was ineffective to not specifically request some sort of a hearing whereby the court can make a determination as to who the first complaint witness was. The prejudice here is that, and again, the argument is that counsel should have understood that this could have raised some issues to help the defense. I guess the best way for me to think about or to frame the motion for new trial is, and this might be a stretch, but to view it as a criminal defense lawyer. These cases are often very difficult and often hinge on just the testimony of the victim. And that always puts the defense in a poor position because usually a young female who's claiming this type of abuse can always invoke sympathy from the jury just by the nature of the allegation. Now, I'm sure I've done enough of these types of cases, and I'm sure you have too, to know that there are experts that can be called, and in this case, while that didn't occur, between 12 and 20% of children can fabricate on the stand, and there are always red flags. One of the red flags that I saw here was the fact that the children were always happy to be in Mr. Bergeron's presence and looked forward to being with him and spending time with him and getting ice cream. And that's kind of a red flag for one of these types of cases. That's just framing. This wasn't argued. I'm just framing
The stats weren't.
No, I'm just framing kind of the way I want you to look at this, and that is when trial counsel approaches this type of a case with just a strategy of cross-examining the victim, that should always raise the specter of ineffective assistance of counsel. And in this case, what Attorney McNiff is trying to show and raise is there's a issue here at that moment when more than one first complaint witness was shown to be out there, that more should have been done. And
So,
I even
let me just interrupt you for a second. So reasonable minds might differ as to that point, right? I mean, here we have a very experienced trial counsel, right?
yes,
Okay.
and yes, reasonable minds can differ.
He brought in a co-counsel, right?
Yes,
He offers in his affidavit a very strategic reason as to why he didn't push back as to the change in first complaint, right?
he did. Yes,
Court found that reasonable.
the court did find that reasonable, and yes.
Is it unreasonable on its face?
So again, you have to look at it. It's going to be viewed differently from a different point of view, and where you have constitutional protections of due process, my hope is that you'll look at this in the sense that it needs to be a defense, a valid defense needs to be more than just cross-examining a victim. And in this case, more could have been done, and that's really what the idea behind requesting discovery was in the motion. And if you look, I believe Attorney McNiff even spells out reasons why he felt that the motion should be allowed and what they were hoping to achieve. Hold on a sec. I just had that. Anyway, it's yes. So on page 61 of the appendix, he lays out a nice
Volume 1 or 2?
Volume 1. I'm sorry.
Thank you.
He lays out a nice summary of what they're hoping to find in the motion if it was allowed, at least looking at more evidence. Now, I understand the high bar that the appellant faces here on a motion for new trial, but I hope that you can weigh that against a meaningful, or the hope for a meaningful defense in a case like this. These are, again, difficult cases, and where trial counsel feels more, or I'm sorry, where the motion counsel felt that more could have been done, my client's hope is that this court will look at that and make a determination as to whether maybe in the future courts should take a little bit closer look at first complaint witnesses. Because you can also, and trial counsel could also play off of the fact that different versions were given to different witnesses and the times. And again, I think this is what counsel was hoping to elicit.
At the end, he felt that the ones that the Commonwealth landed on were better for his guy.
He did. Yeah, that's in his affidavit. That's right. But again, look at the whole. I mean, I get picking points out of a trial, but I need you to look at the broad scope of a criminal defense in this type of a case. And again, the whole strategy here seems to have been, well, let's just cross-examine and go on off of whether this victim is being truthful or not. And I'm not sure that always provides an effective defense for somebody who's accused of this type of crime. Any questions about the motion for new trial further?
If I may, I have a question about your second issue.
Oh, okay. Let's move on to the second issue then.
You know, rape of a child by force. The Commonwealth's best case, I believe, is Armstrong, 73 Mass Ave Court, 245. Can you distinguish Armstrong?
Well, so I feel like I'm in a bit stronger position than case law because I have the statute. And it makes perfectly clear, if I can find it.
I'm aware of what the statute says, but I think the Armstrong case stands for the proposition that constructive force in certain circumstances can be enough when there is a disparity in age, when the defendant is in a position of authority, power over the victim, when they live together, and when there's an ongoing course of conduct. So,
When I get statutory, or when I get case law that kind of goes into those words that really aren't even used in the statute, and I understand why, so again, let's go to the statute. And compels such child to submit by force, and compels such child to submit by force. That's different than just statutory rape. You have to apply the words as written and avoid the temptation, which is great, to use the case law to kind of envelop greater and greater conduct. All that occurred here was, and I get that the familial relationship, they were close, but there's no force that's being applied here. There's no threat. The threat was to remain silent, but we don't know if that occurred, we don't know in what context that occurred.
See, that's why we need the transcript, because would you agree that if this is a course of conduct that, let's say, happened over 5 years, and in year 3, the defendant said to the victim, if you ever mention this to anyone, I will hurt your family, and then the conduct continued, under the hypothetical I just gave, would that be enough to meet the compelled by force element?
I think that could.
So the timing of the threat here may be relevant to our analysis.
Yeah, no, the context is everything here. Here, it's vague enough that it's not, you're not going to be able to determine that this was a threat to compel. And if, I cite portions of it in my brief that I think are helpful, but again, in the end, this is a sufficiency argument.
Is there any indication in the record as to when that threat occurred?
No, not that I can see. I don't think there is. Beyond the scope of the, in fact, here, let me.
So we're going to need the transcripts of the relevant testimony. We have only portions of it. But it strikes me that a key to your argument is not only when the threats were made.
It's the wording. It's
the wording, but it's also what inferences can be drawn from the timing of threats.
Yes.
Okay.
She was 5 years old when the rapes began?
Yes, around that age.
And 12 or 13 when she reported them?
Yes.
So I have one further question for you on this issue. You state that the error requires reversal and dismissal of the rape by force indictments. My understanding is that if we were to agree with you, the case would be remanded for the proper result would be a remand for resentencing on the lesser included offense of rape of a child. Do you agree with that? I don't think we dismiss. I think if the element of force isn't met, the evidence is still there for the lesser included conviction.
There would be for the lesser included, but it's the government who charges, and in the end, it depends on how the defense is played out, whether it's kind of an all or nothing, and the jury is able to look at the lesser included. But in this case, I have to go back and check the transcripts. I don't remember off the top of my head, but if the government and the court plays or sets up the prosecution where that's just what the jury looks at, and the jury, and there is a sufficiency problem of the evidence, then I think that the proper course of conduct would be to reverse.
Seeing no further questions, thank you, Attorney Benyon. And Attorney Walsh?
Thank you. Good morning. May it please the court. My name is Emily Walsh. I'm an assistant district attorney from Middlesex on behalf of the Commonwealth. The first complaint issue in this case is relatively straightforward. There was no objection to the Commonwealth's designation of the cousin as the first complaint witness. Both parties agreed. The motion judge then found that, quote, where, as in this case, there's no factual dispute about who is the first complaint witness, then there is no need for such a voir dire. The decision not to challenge the first complaint witness was a reasonable strategic decision, as reflected in both the pretrial hearing transcripts and in trial counsel's affidavit. At the pretrial hearing, July 25th, 2014, after the Commonwealth designated the cousin as the first complaint witness, trial counsel stated, quote, we are content that the first complaint witness identified by the Commonwealth is the first complaint witness. Then in the affidavit in support of the motion for new trial, trial counsel said, I was surprised and somewhat pleased to learn that the Commonwealth would not be calling either of the two young, quote, Game of Secrets participants. In my opinion, the cousin's story would be less harmful to him than the story about the earlier Game of Secrets.
And there were two trial counsel, right? Didn't
Correct.
the attorney also have another lawyer assisting him?
Correct.
And is that similar language in that affidavit as well?
Correct. Yes. I believe I was quoting primarily from Osler's affidavit, but they both have similar recitations about the strategic decision and feeling happy and somewhat surprised, but happy about the designation of the cousin as the first complaint witness. The motion judge found that trial counsel's decision not to challenge the first complaint witness designation was, in fact, a reasonable strategic decision. As to the force issue, I don't know if your honors have volume 3, page 46.
We do not.
I will certainly make sure that's submitted. In the interim, that is where she is asked, the victim describes the abuse. She's asked on direct, would that happen more than one time in those 7 years? Answer, yes. How often? I'm not sure. More than once. You didn't tell your mother? No. Why? Answer, I was scared. What? I was scared. Of what? Answer, of him hurting my family. What do you mean of him hurting your family? He threatened me and told me that if I told anyone, he would hurt my family. The timeline of that threat is not clear, but this is a 5-year-old victim left in the care of an authority figure who she testifies that she is scared of. That is more than sufficient evidence to show constructive force.
So you're saying that under Armstrong?
Not only Armstrong, but yes, Armstrong, Wallace, those cases stand for the proposition that constructive force is sufficient.
I understand that, but does Armstrong stand for the proposition that any time we're dealing with a rape of a child case and you have a disparity in age and they live together and there is supervisory capacity or supervisory history, that any rape of a child is rape of a child by force?
Certainly, each case would turn on its specific facts.
I'll throw in the fact that, and the child expresses that they were in fear of the person. Does that mean it's rape of a child by force every time?
I don't know that it would every time, but certainly in this case, the specific age of the victim matters. In Armstrong, the abuse happened between 11 and 14. The victim here, it was 5 years old. That is a very, very young child. I do think that that is relevant to the inquiry and to the effect of the grooming behavior, the power disparity. I would suggest that the power disparity in Armstrong, just looking at the age, is different, and that was still sufficient to be constructive force. The case here has the same things in Armstrong's in terms of the relationship, the circumstances, the no power to resist, and the victim is even younger and arguably less powerful with less ability to resist. The fact that it was not in the statute, the constructive force, the job of this court is to interpret the statutes, and Armstrong and other cases interpreting Armstrong have consistently held that it's sufficient. In terms of cases that haven't found...
What 4-, 5-, or 6-year-old child would have the ability to resist?
Perhaps none, but
None.
each case turns...
So then Right, so
So
you're not
a-
making the argument that anytime we have rape of a child at the age of 4, 5, or 6, it is automatically rape of a child by force?
I do not agree with that. It's certainly a strong case that there is constructive force when a victim is that young and powerless and testifies to being in fear. But looking at a case, Feijoo, which was not a rape of a child, but it was a rape case where the court found insufficient force, it was because the 17-year-old victim was submitting to the defendant in exchange for a benefit. I believe he was going to be his...
Feijoo, that?
Yes, I believe he was hoping to be his protege. It was like a karate teacher or something. I suppose there could be a set of facts where a very young victim testifies that they submitted because they were promised a reward and didn't testify to fear. Perhaps there may be some fact pattern that's similar to that, but this is not that case.
If we were to disagree with you hypothetically, is the remedy dismissal of the indictment, or is it resentencing
not.
on the lesser included?
It would be resentencing on the lesser included, but...
Do you have authority for that?
I can't cite a case off the top of my head, but certainly there was sufficient evidence of constructive force in this case. For the 5-year-old, the abuse continued for 7 years. She did testify that she was scared. She did testify to threats by the defendant, and the first complaint witness described the victim's demeanor when she revealed the rapes as nervous and scared.
So I'm going to repeat what I said at the outset. The court is asking you, after argument, to get together to give us the entirety of the victim's testimony and any other testimony that bears on the issue of constructive force, or any other transcript testimony from anyone that you say bears on that issue. You should provide the court.
Thank you. If there are any further questions?
Yeah, that's, as Justice Desmond aptly suggests, that should be within, let's say, 10 days.
Very good. Thank you.
Any further questions? No. Thank you both. Very good arguments. The case is submitted. Our third case, 22P361, Commonwealth v. Borland. Keep going, if they're here. Attorney Arter?
Good morning. My name is Corey Arter. I'm here on behalf of Melissa Borland today. I'm here on this matter, and I've submitted to the court 3 arguments. I will probably defer on the papers on the first, which is the sufficiency of the evidence argument. Would like to jump to the second. By way of very quick background, this case arises from an incident in the apartment of a neighbor of Miss Borland on October 3rd of 2018. There's some various dates in the memorandums, as initially it was testified to be November, and I believe there's a typo in one of them that says 2014, but it was October 3rd, 2018. Commonwealth contended at trial that Miss Borland went to visit her neighbor, Mr. McCraddock's apartment, was having a lovely casual conversation with him, petting his cat, and then all of a sudden grabbed a hammer and hit him on the back of the head several times. At first blush, hearing those facts, I'm sure the court would wonder why it was that we're here today. It sounds like a pretty open and dry case. However, officers who testified on behalf of the Commonwealth testified that in investigating this case, they spoke with Miss Borland, and she said to them that Mr. McCraddock had, that she was sitting talking to Mr. McCraddock, everything was fine. He got on top of her, knocked her down to the bed, pulled her pants down, was on top of her, and that she grabbed the first thing that she could.
She testified to that at trial.
But also, Officer Egan testified that when he investigated, on the date of the incident...
The defendant submitted a statement, sorry, the victim submitted a statement.
The victim, I believe, spoke with Egan. He went back a second time. On the date of the incident, she doesn't say much of anything. She asks...
This is in the morning, right? What time of day?
It was in the morning. It was probably like 8 in the morning. According to Mr. McCraddock's testimony, she comes next door, wanted to use his phone, didn't have a phone. They're neighbors in what appears to be a housing a rooming house.
You indicated that she told one of the responding officers that he assaulted her and jumped on her?
Yes.
And yet they arrested her.
And they arrested her. Now, they talked to Mr. McCraddock first. They talked to him on the date of the incident. They talked to him again. On the date of the incident, the only thing that Borland says is he okay?
Mr. McCraddock has a disability. Do we know what that is?
I do not know exactly what his disability is. There's some evidence that it wasn't a physical disability, that it may have been a.
Evidence is there of that?
In speaking with the officers, there was no evidence that he was physically limited in any manner, that he got up, he was able to walk out, he just had a cut on his head. So my understanding, based on the evidence that we do have about what his condition may have been, he was able to walk, he was walking around fine, but he was holding his head. So I don't believe that it was physical in that he was disabled and couldn't get about by himself. With regard to the sufficiency of the evidence argument, as I mentioned, I'll mostly rely upon the argument. I do concede and counsel's argument that the credibility of the witnesses is within the purview of the jury. However, my point in making the first argument is quite simply that in order to prove assault and battery with a deadly weapon, they have to prove that she has some intent, or that the touching was not justified. And if you believe her testimony, or you believe the testimony of Egan, who then also confirmed she had no pants on when they arrived.
You said earlier that Detective Egan, is it officer or detective?
I'm not sure that I know it was Egan.
Testified that he spoke to the defendant and she said to him that she was the one who was attacked? Where does it say that? I'm looking at Egan's testimony. I don't see that.
There is, Your Honor, my memory is that
My memory is that the
police report goes into evidence, the supplemental report, and Egan testified that he went out subsequently and had a conversation with her before she was arrested. Wasn't arrested on the date. First officer was mainly involved with date of incident.
Where is Detective Egan's testimony regarding what the victim told him?
I believe, Your Honor, that Egan testified he went out, separately prepared a report. There was that, the report was within the evidence that was submitted. My understanding, and I apologize, I don't have the site of the record. My understanding is that he testified that he went out subsequently, he had a conversation with her wherein she said these things to him that was contained in the report that was submitted into evidence in the Commonwealth's case. And I do apologize that I can't point to the exact place.
Saying the police report was marked as an exhibit.
Yes.
Entered into evidence.
Yes, I believe so. And I believe they both referenced it on the stand.
They referenced it, but it would be unusual for a police report, a hearsay document, to be entered into evidence.
And I do apologize, Your Honor, but it's my memory that the statements of Egan, the statements of Borland in speaking to Egan were part of the record.
Do we have the report? And if so, can you tell us where it is?
Thank you.
We have it?
Yes, I believe that it, and I really apologize for having to flip through my statement of the facts, but it was my memory of the facts, Your Honor, that there was evidence presented in the Commonwealth's case through Egan that this is what was told to him on the subsequent date that he went out to visit with her.
I don't see the report in either of the appendixes, so.
I apologize.
I don't see the report in either the appendix or the amended supplemental appendix.
I think you're confusing. The officer, Detective Egan, went to speak to Mr. McCraddock. The defendant, Ms. Borland, was arrested the day of the offense. So I don't believe the evidence shows that the officer or Detective Egan re-interviewed Ms. Borland and she made the statements you're attributing to her. I believe the statements you're attributing to her were from Mr. McCraddock in a letter he wrote or in a prior interview he gave to Officer Egan.
My second point on the evidence regarding the self-defense argument does come from the statements from Mr. McCraddock, in where he does testify that, and the officers do testify that he says to them that she was yelling, "Get off me, are you trying to rape me?" and she was yelling it aloud. McCraddock, their discussion with McCraddock, his statement changes several times, from the first date to the second date. And
Can I ask you about that? So in his initial statement, in his direct testimony, there's no testimony about the rape statement or the "you're hitting me," correct?
Yes.
And on cross-examination, the strategy was to impeach him. Is that correct with his prior statements?
Yes, and also my understanding is that the officer who followed up, and I do apologize, I believe that it was Egan, testified that when he spoke with him again the second time, when there wasn't an emergent problem, that he wasn't holding his head, that he does tell the officer that she says, "Oh, you're on top of me, you're trying to rape me." They did observe physically that when they arrived that she had no pants on.
Let me ask you again about the nature of these statements.
Sure.
The statements about "get off of me" and "you're raping me." They were first directed to Mr. McCraddock on cross-examination, correct?
I believe, yeah, Mr. McCraddock, first to Mr. McCraddock on cross, but I believe that Egan confirmed that this is what on...
On the statements that Mr. McCraddock, as he was addressing or responding to, these are prior and consistent statements he made in an interview with Officer Egan and a letter he wrote, correct?
Yes.
And so you're admitting or conceding the nature of those statements were impeachment.
But they were evidence in the case, and they were before them, that Officer or Detective Egan's testimony confirming that in a subsequent interview, McCraddock does talk about these statements that she was saying. McCraddock does address that on cross-examination. My point, Your Honor, is for purposes of the defense trial counsel requesting an instruction on self-defense, if any evidence would support the defense, the judge is required to give the instruction. Any evidence, any view of the evidence. So if you believe her standing there with no pants on when the officers arrive, if you believe she's upset, they take pictures, both testify she has defensive type wounds. They take pictures of scratches on her arms. The testimony is that at some point, even if you believe McCraddock's sort of version of it, they fell onto the bed and he was on top of her. I think that any view of the evidence, some view, without regard to credibility of the witnesses, that some view of the evidence would support that at some point there was a struggle between the two of them. Mr. McCraddock admits that she did indeed, during this struggle, say, "Oh, well, yeah, concede that she was yelling out, 'You're trying to rape me,' or, you know, 'You get off of me, you fell on top of me, get off of me.'" These statements come in, whether they come in through cross or whether they come in through Egan confirming that he had a subsequent conversation with him where he said, "Well, she was yelling these things," or the subsequent report. There's some view of the evidence that would support a self-defense argument here. It's not out of the question. It's not out of the blue. It's not something that this judge couldn't get from the evidence that was presented. And the problem here is that the trial counsel presents at the beginning of the evidence a request that he get the instruction on self-defense. She said she would defer until the close of the evidence. At the close of the evidence, she renews it. Counsel says that, you know, you're putting us now in the position where we have to make a decision mid-trial to call Ms. Borland to the stand. The judge's denial of the request at the close of the evidence to give the instruction forced their hand, requiring Ms. Borland to take the stand in order to affirmatively prove her defense. I would suggest that there is a view of the evidence which would support her self-defense argument. That's all that you need. It's any view at all of the evidence would support it. Scratches on her arms, evidence that she was in a struggle with Mr. McCraddock.
There was no dispute that they were in a struggle, right? That's fairly undisputed. Even Mr. McCraddock, the alleged victim, says that we were tussling and she was yelling these things. So evidence of scratches, how does that show self-defense?
Well, it's consistent with her, or the evidence that came in through McCraddock and Cross, or the evidence from that he even says, "I'm on top of her at some point. We fall down, I'm on top of her on the bed. She has scratches on her arms. The police thought that they were important. They took photos of them." The evidence that he's on top of her at some point on the bed, not that she just randomly comes up behind him and hits him on the head. Evidence that there were scratches.
But this was in the context of the kidnapping charge.
I'm sorry.
The testimony was that she sat down next to him. She was quote-unquote being nice. She grabbed his head, which is ostensibly the assault and battery, and took the hammer and hit him several times, and that's the ABDW. The testimony is then he tried to escape. He went to the door. She grabbed him. She goes down on the bed and pulls him on top of her. That's the testimony. And that's when ostensibly we can infer that the struggle back and forth occurred. It's clear from the victim's testimony, it's trial transcript page 98, when he's asked about that she having pulled you down and said, "You're attacking me," the response from the victim was, "That's after the hammer incident." So all of this is a big windup to this question. What is the evidence that, as to the timing of the tussling? The only evidence I see of that is that it occurred after the A and B and DW.
I would concede, Your Honor, that this is a question of credibility. I would concede that with regard to the sufficiency of the evidence, this is something that goes to the jury. However, with regard to the request for the instruction, while this is not an overwhelming case by any means, I think that there is some view of the evidence wherein a jury could find that she was acting in self-defense. Some view of the evidence, any view of the evidence.
The jury could certainly disbelieve parts of the victim's testimony, but disbelief of that testimony is not evidence of the opposite conclusion. In other words, if the jury or a jury were to have disbelieved part of the victim's testimony, that's not affirmative evidence that the opposite conclusion, i.e., the attack occurred later, happened.
But that's a view of the evidence. And Your Honors, I do understand, but my position on the instruction, which I think is frankly, one of the only really viable, strong arguments, is that there is a view of the evidence wherein the jury could find that she was acting during this interaction in self-defense. My position on the instruction is that...
What is the evidence outside of her testimony?
Outside of her testimony.
Outside of her testimony, what is the evidence that there was a wrestling match or struggle prior to the hammer hitting incident?
Your Honor, I would suggest, again, it's the evidence of the scene. It's the evidence of McCraddock, again, whether on cross, it is a view of the evidence, admitting that at some point he's on top of her, that there is a struggle. I do understand that this is a close case. I absolutely understand that.
At the end of the day, at the end of the day, she did get the self-defense instruction, right?
At the end, but the denial at the close of the Commonwealth's evidence is that the counsel then was faced with the untenable position of having to put his client on the stand and make a real-time trial decision, knowing that there were contradictory statements in the evidence, opening her up for not looking like a credible witness, which had the judge agreed to give the instruction before they had to make that real-time decision.
Aren't lawyers called on to make those difficult decisions all the time?
Absolutely. And
Just a housekeeping question. There were a number of portions of the transcript where it was reported as inaudible, including the very self-defense part of the instruction. In Rule Mass Appellate Procedure Rule 8, I believe it's 8.3, requires the parties, this is they shall attempt to stipulate to the missing audio, and if they can't come to a stipulation, they shall essentially ask for the court's assistance. Was that done here?
There were calls put into the office. I believe that counsel and I, there's one, best that I can see, the argument requesting it, the portion of the argument, and in counsel's brief also consents that that portion of it requesting the instruction was a renewal of the request that was made prior to trial based on the section that was missing. I did call the district attorney's office and discuss it, that there is one small section that was missing. We both agreed it was just the request itself, and it was a renewal, and based on the remaining portion of the sidebar conference that was present, it was my understanding that the record itself, that we could agree that that was the portion of the record that was missing.
You're saying you're resting on the record as provided to us?
Yes.
Okay.
And I do appreciate your courtesy. I will rest on my papers.
Thank you.
Thank you.
Thank you. Very well briefed. We appreciate the argument. We'll now hear from the Commonwealth.
Thank you. If it may please the court, Elizabeth Mello Marvel for the Commonwealth. In regards to the self-defense instruction, in looking at the evidence that was part of the Commonwealth's case, at the close of the Commonwealth's case, the only possible evidence in regards to a self-defense was the victim's testimony of what the defendant was yelling. And in the defendant's brief on page 32, they make reference to ample consistent evidence from each witness as to the defendant screaming aloud that she was in fear. I'm not sure who these three witnesses are. If it was the victim who testified to that, and then officers testifying that he said that. So it's a repeat of the same thing. When officers responded, and it's in their testimony, the defendant said that she had an interaction, I can't remember the exact phrase, but it was, or a dispute or something along those lines. It was a very vague sort of comment with the victim, commented that he was bleeding badly, asked if he was okay. She never reported being attacked, never reported to any officer that she was in fear, that she was trying to get out of that apartment, that anything of that nature. There was no report of that, and that was consistent in the officer's testimony. And in addition to that, they interviewed her boyfriend who was on scene, and there was no report made to him that she in any way was attacked, in fear, had made any effort to get out of that apartment. And in looking at the circumstances in which a defendant can appropriately request the instruction, they have to show that they used all proper means to avoid physical combat. It's only in those certain circumstances that they were in fear. And in here, all of the testimony, if you look at transcript 1 on page 66, there's testimony about the defendant pushing on the door to prevent the victim, again, that goes to the kidnapping charge, from leaving. But she doesn't leave the apartment. It doesn't end at that point. There's testimony that once he makes it out of the apartment, he testified she's trying to drag him back in, and he's hanging onto the railing, asking people to call for help. He's the one that calls 911 with the 3 wounds to his head. Again, there is no evidence that she took any action to avoid any physical combat at any point. There was no testimony that she made any sort of report until she testified. And again, in regards to the ineffective assistance of counsel, there's reference made that this was a split-second in-trial decision. That is not something that can be determined from the record as it exists here. There is no affidavit from trial counsel indicating what conversations they did or didn't have, what their plan was, or even whether if the defendant decided to testify against advice of her counsel.
Going back to the absence of a self-defense instruction, what's your
Yes.
best case for the proposition that the judge did not err in refusing to give the instruction
The best case for that, Your Honor,
under this set of facts?
I apologize. I pulled another case, but it is an unpublished.
What's
Look,
your best published case?
Commonwealth v. Mercado, citing Commonwealth Benoit. So Commonwealth v. Mercado, 456 Mass 198. It's a 2010 case citing Commonwealth v. Benoit. And that is talking about using proper means to avoid contact, to avoid physical combat. And in the Commonwealth's case, it was presented with what the judge heard and was looking at in determining at the close of the Commonwealth's case as to whether or not an instruction was warranted at that point. There was no testimony in regards to the defendant's actions in that way. If she had made some kind of comment to law enforcement and they were then able to testify to, we got there and she said this happened, that happened, this happened, that
That would
happened,
be sufficient.
they would have testified to that arguably would have been sufficient. Here, there was no testimony. The only thing that was there, potentially viewed in the light most favorable to the defendant, was the victim's statement that she said, "You're attacking me." That was it. That was all they had. And it's the Commonwealth's position that that is simply not enough. It wouldn't make sense for that to be enough to warrant a self-defense instruction, because presumably a defendant could do anything, be performing any action, so long as they yell out during that assault, "You're attacking me," that would be enough for a self-defense, and that wouldn't seem logical.
I'm not sure I agree with you. I agree with you in the sense of the timeline here. Again, at transcript page 98, the victim testifies that that occurred after. The only testimony and evidence, however, about the attack itself is that it was an unprovoked, instantaneous attack and that everything occurred thereafter. But if the testimony was, without reference to a time frame, if the victim testified, "She said you're attacking me," and there was no other evidence as to time frame, wouldn't that be sufficient for a self-defense instruction?
If that's the only statement,
Yes.
and it comes from the victim, and there's no report to the police or anyone else?
It doesn't have to be a report to the police. It's any view of the evidence. If there's no reference to timing, it strikes me that would be sufficient for an instruction.
Respectfully, Your Honor, in looking at the case law, I was not able to find a case that says that all that would need, that it's sufficient, that it would be enough, only with just that statement. So I apologize.
Oh, no apology needed.
I was not able to find a case, or am aware of a case that stands for that proposition. If there are no other questions from the panel, the Commonwealth would rest on its brief.
Okay. Seeing none, thank you. The case is submitted.
Thank you.
Do we have counsel on 22-462? I hope I pronounced this correctly. Loiselle versus Tennyson-LOISELLE?
Yes, sir.
Both parties? And Attorney Levy?
Yes. Good morning, Your Honor. May it please the
Morning.
Court. Jeff Levy for the appellant, Kenneth Loiselle. This is pretty well laid out in the briefs, I think, Your Honor. This is a case about contract interpretation. Neither party is relying exclusively on the plain language of Exhibit E to the separation agreement. A review of the brief shows that both parties are looking to the context of the entire agreement and to evidence of the party's intent at the time that the agreement was made, which is appropriate. That's the way contract interpretation works. We should be considering all of those things. And certainly the language of the agreement is the most important, but in this case, where I think there are two possible interpretations of the contract, it makes sense to go back and look at the agreement in context.
Let me just ask you a preliminary question.
Yeah, sure.
The separation agreement contained an integration provision, correct?
Yes.
Okay. Did the modification, do you agree that that was an integrated agreement as well?
Yes, I do, Your Honor.
Okay.
See that. So it's important to view the entire agreement and the modification in context and together. And the appellees, my client's ex-wife and daughter, are, for instance, point to language in Exhibit E about what happens if Mr. Loiselle dies, the trust is established, and then his daughter were to die before she reaches the age of 35. And the fact that...
If you could stop for a second.
sure.
I'd ask our clerk to start the clock, please.
I don't think I'll use all my time, Your Honor, anyway, so.
Thank you.
That if Mr. Loiselle were to die and then the trust is established and that at the age of 35, that his daughter would receive the remainder of the trust as evidence that this was intended as a bequest that would happen unconditionally no matter what. On the other hand, I think it's important to note that if in a situation where artists were to predecease Mr. Loiselle, even if she had issue at that time, even if she had heirs, they would not receive the bequest at that point because Mr. Loiselle's obligations are complete. There's no provision for that trust to be paid.
But the agreement doesn't say that, right?
Right, right.
At the time of the agreement, he didn't have any other children, did he?
Yes, he did, Your Honor.
How old were they?
I don't know that, Your Honor. It's not in the record.
But that was through a separate marriage, though,
It was
correct?
a separate marriage, exactly, yes. Yeah, Your Honor, this was a one-year plus marriage with one child, but he did have other children at the time. And
So let's cut to the chase.
yeah,
If we look at Exhibit E, and I think it's subparagraph D, it says something about upon the child attaining the age of 35 and what would happen. Your argument, as I understand it, is that the obligation should have ended in 2011 when the child would have been 19 years old. Is that correct?
well, no, Your Honor. I think the obligation ends when Mr. Loiselle's obligations to artists are fulfilled, and that included paying for college and graduate school. So I would
But
say,
reasonably, it would have been before she's 35, a reason.
yes, exactly, Your Honor, yes.
So then what is the purpose of including that provision upon the child attaining the age of 35? I'm having difficulty reconciling that provision with your argument.
I think that if Mr. Loiselle had died at that point, that certainly at that point,
At what point, I'm sorry?
if Mr. Loiselle had died before artists reached 35, and before he had completed his other obligations, is really what I'm saying, before he had paid for all the child support and for graduate school, then it just follows that the trust had been established and that she would keep
But then
the
why
remainder.
not say that? Why not say that in either the separation agreement or say it in the modification and stipulation? That's your challenge in
It
this
is my
case,
challenge,
right?
Your Honor, I understand that, but respectfully, I think that the agreement also doesn't specify that that the trust in Exhibit E is to exist in perpetuity until Mr. Loiselle passes away, even if all of his other obligations are complete. I think, looking at this as a lawyer, if I had been there at the time, might have used different language, certainly. But at the same time, I don't think it's clear from the agreement from Exhibit E read in context that that this was intended to continue on out forever.
And so the record's clear. You were not the attorney who drafted the separation agreement.
Correct. In fact,
You did not participate in the stipulation and modification.
Correct. And I wasn't even the attorney at the trial court in this case. I'm really here for the appeal.
Understood.
So I understand the challenge, Your Honor, but I think that the canons of contract interpretation suggest that we should look for a reasonable result here. We should look for an interpretation of the contract that makes sense in context. And it doesn't make sense in context that Mr. Loiselle, at an age in his late 40s, with other children, other family, the possibility of another spouse in the future or another partner, and not knowing this child, not really having much of a relationship with his wife, who he'd only been married to for a year, would pledge a quarter of his estate under...
Certainly cuts both ways, though.
That's why we're here. That's why we're here, Your Honor.
It could be a reasonable interpretation, the absence of a relationship or the age at which the child was at the time of the separation agreement was executed cuts both ways. On the one hand, you could say, well, there wasn't much of a relationship there. On the other hand, you could say, all the more reason to have a financial obligation.
Well, and
Both are reasonable interpretations, is my point.
I think I might
It's
disagree.
really not it's not necessarily that they're reasonable, but that they are not unreasonable.
Well, I might respectfully disagree, Your Honor, in the sense that Mr. Loiselle, the evidence in his testimony in an affidavit in this case, is that he spent over $1 million over the years in alimony, child support. It was really alimony that was in the nature of child support, and in paying for boarding school, college, graduate school. He understood that he had obligations to his daughter.
If the documents are truly unambiguous, do we get to that testimony, and do we get to parole evidence? I understand you're arguing in the alternative, but assuming that we agree that the provision is unambiguous, do we consider such evidence?
I think you can, again, consider extrinsic evidence that helps to elucidate the party's intent. I suppose...
I was always under the impression that if it's an integrated agreement and the provision was unambiguous, we don't look to that. I thought that only came in the event of an ambiguity or an non-integrated agreement.
I think that the case law I cited, Faith, Spofford, and Thorndike, and some of the other cases would suggest that it's appropriate to look to the agreement in context and to consider, and not any evidence that would contradict the plain language of the agreement, certainly, but evidence that would help to elucidate the party's intent is helpful. And
if it was unambiguous, why would we be looking to elucidate the party's intent? Why would we even be going through that exercise?
I suppose that it means, Your Honor, that there have to be two potential interpretations, which is what we have here. If the court does find that it's ambiguous and that neither of the interpretations is more likely than the other, then I have, in the alternative, asked for this to be sent back for trial. And I do want to point out that, and I think it's important, that in her decision, the trial justice misstated the facts about the availability of life insurance as a guarantee for Mr. Loiselle's other obligations at the time of the 1993 agreement. The evidence, again, is that
he said it was cost prohibitive, right?
It was cost prohibitive. He had just had surgery. He had a heart issue, and
is there any other evidence other than his affidavit?
No, but there's no evidence to the other effect either, Your Honor. I mean, that affidavit was put in. There's really no contradictory evidence. I know that his ex-wife submitted an affidavit saying that she understood that he had life insurance in connection with his previous divorce to guarantee his obligations in that case, which I don't know, Your Honor, that may be true. But there's no evidence contradicting his testimony.
This person's a multimillionaire, right?
Yes, Your Honor. Yeah.
Just looking at Faith Spofford right now, again, you cite to page 342 of that case, and that case deals with an ambiguous term in a contract. It deals with two things. One, term that was not supplied in the contract and where the court had to fill in that void, and two, dealt with an ambiguity. So I'm not sure that that is your best case for the proposition as to why we're considering extrinsic evidence here in the face of an unambiguous proposition. Is there another case you'd like me to look at?
If it's not in my brief, Your Honor, there's no other case that I'm going to cite to today. So if you're,
okay.
I'm not going to lead you down a path to other cases.
No, and I understand some of the cases are somewhat inconsistent. They say that with an unambiguous integrated contract, we just look to the terms, but in plenty of cases, there's at least dicta where they do look at some of the either testimony or extrinsic evidence. So I understand why you're making that argument. It's not lost on me.
Yeah, I think the McAdams case, which is a First Circuit case, McAdams versus Massachusetts, which is on page 21 of my brief, agreement should be construed with reference to the situation of the parties when they made it and the object sought to be accomplished. This sort of contextual evidence is not the kind of evidence intended to be barred by the parole evidence rule if no ambiguity is found. Rather, context should be used as a tool to find unambiguous meaning in the first place. So I think we're trying to find the unambiguous meaning in the first place here. And sometimes you have, I understand that seems contradictory, the notion that it's unambiguous and we're trying to find unambiguous meaning. But I think in this case where you have a contract that is, it's clear. I think you can read Exhibit E, you can read the entire contract, and you can say it's clear. At the same time, I think you could have two different interpretations of it. You could have the interpretation that it is intended as a guarantee of his obligations. You could have the interpretation that it is intended to continue on past his obligations. So just to go back for a moment to the trial court and the life insurance issue, I think it's important that the trial court not only ignored the evidence that he was unable to obtain life insurance, but flipped it and wrote in her opinion that if he wanted to guarantee the obligation, he could have obtained life insurance, when the evidence is that that was not really available to him. So
What's our standard of review here?
de novo, Your Honor.
Right. So do we look to whether or not the judge made a mistake? Or
No,
we
I
do
just
it on
wouldn't
our
want the
own?
court
Right.
to read that and think that that's correct, Your Honor. So if the court doesn't have any further questions, I'd rest on my brief.
Thank you very much.
Thank you, Your Honor.
Be Attorney Carter today.
Good morning. May it please the court. The lower court's judgment simply denied appellant, and I'll refer to the appellant as father, attempt to modify terms that are simply not modifiable. Father sought to modify language which was clear and unequivocal in its meaning, and more importantly, it survived as an independent contract.
So the court says that the defendants argue that the plaintiff is attempting to modify terms, as you say, that are clear and unequivocal in meaning and survive as an independent contract. The court agrees. So that's the court's position, but we reviewed de novo, right?
Well, so if you want to look at it from start to finish, you have a separation agreement back in 1993, totally modifiable. Puts in the estate plan, he puts in all the terms and things of that nature. 18 years later, in 2011, he goes back. And what happens when he goes back? And that's the time, whether you want to believe about life insurance and everything, and I'm telling you that's just a red herring. But 18 years later, you got a 19-year-old daughter. It's the time to take the estate plan out if you want to do that. But what does he do? He changes it. He doesn't take it out.
They negotiate, he gets the New York home off the bottom and the $2 million or...
Correct. Takes the condo out, reduces it significantly, which is a significant reduction. And they negotiated. This is a stipulation. And under Bacombe, you have to assume they negotiated to their reasonable satisfaction. But 18 years later, you got a 19-year-old child. If you want to believe everything they say, that's the time to remove it, or that's the time to do something else. And he does do something else. He reduces it significantly. And then he puts his stamp on it and reaffirms and says, this will survive and have independent legal significance and be binding on not only me, but my heirs and assigns. More importantly, he, at that time, understood child support, the issue of education and health insurance. I'm going to leave that over here so I can modify it at a later time. So he knew, there's no confusion here. He knew these terms, child support, education, and health insurance, I'm able to modify down the road.
Have you ever seen in your experience a provision like Exhibit E in the separation agreement in explicitly the bequeathing a trust of 25% of the adjusted gross estate to a relatively newborn child?
I have actually seen estate plans in divorce agreements.
Plenty of them. Have you seen one like this is my question.
But 25%, no, I haven't seen that. But saying that, you, as I think you referenced earlier, you had two different levels of means here. You had a multimillionaire versus somebody who literally had no means. And this was a way to protect and a way of a property division or whatever, to care for this child for the rest of the life. He had 2 other children, and if you want to get into life insurance, he had, at least according to the affidavit that was submitted, a life insurance policy already. This was his way of not paying for a life insurance policy and his way of protecting his daughter. But you have to look at 18 years later, and you have to look now, 29 years later, he comes with this new narrative. The new narrative is, oh, well, that was for security purposes. Well, whether you can get a life insurance provision or not, you could have simply put into that Exhibit E or in the modification, this obligation that I have under Exhibit E ends on such and such a date. And he did that with the educational piece. He picked, no matter how you want to do it, boarding, graduate school, master's degree, whatever my obligation is, it ends June 30th, 2020. He put that language in there. So he could have easily have put that language in there for his estate plan if, in fact, that was his intent. That was not his intent. His intent was to keep the estate plan. His intent was to call out or pull out certain things that he could live with, such as the condo and the monetary aspect. But after he did that, he simply reaffirmed it and made it non-modifiable. There's nothing that is unclear about that language or his intent in that modification. And that's what the court found. There was no trial. It was all done by arguments. But that's what the court found. He simply does not have the authority or the ability to modify a provision in an agreement or a modification judgment that says it has independent legal significance and survives.
What does Massachusetts case law say about taking extrinsic evidence in a case where there is an unambiguous contract provision and an integrated agreement?
I'm sorry, I didn't hear the last part.
What does Massachusetts contract law say about the taking of extrinsic evidence in the context of an unambiguous contract provision with an integration provision or with an integrated agreement?
I think the parole evidence rule provides that you cannot bring in extrinsic evidence. You have to look at the intent and the language in the writing. And so for that reason, there is no outside. The court shouldn't look at anything outside because the clear intent of the language was what was put down in writing. And
how do you get to intent without context, as the McAdams case your brother cites to says?
You get to the intent by looking at what he did through the whole picture. You look at, in 18 years, what did he do after 18 years?
Well, what he did in 18 years is extrinsic evidence. It's outside the contract.
I'm sorry?
What he did in 18 years is extrinsic evidence. It's outside of the contract.
Right. And so
we do take evidence and we do consider intent outside of the contract? That's my question.
No, maybe I'm not following, but in 18 years, he went back to address the original agreement. And that agreement allowed him to do what he did, modify. He modified certain things, and then he entered into a new agreement that did not allow him to modify anything, that he's now doing another, another 11 years later. That second agreement, which is a modification judgment, specifically does not allow him to now come back 11 years later and say, oh, well, that was something I meant for security purposes if I died. That's not what's written. That's not how it is set out. He certainly, and I don't want to repeat myself, he knew what he was doing by the mere fact that back then he took out three things: child support, education, and health insurance, to argue that he could change that, and he made it specifically in that same judgment that it is modifiable, it's incorporated into the agreement. The estate plan that brings us here today, that was kept outside, non-modifiable, and binding not only on him, his heirs, and his assigns.
Thank you, counsel.
Thank you.
We appreciate your briefs and arguments. The case is submitted. Do we have counsel on 22P771? Calling Department of Children and Families and another versus father. So before we begin, I will remind counsel on this case that this matter is impounded, so please do not refer to any impounded material. Do not use any of the parties' names. You can refer to them as father, child, mother, etc. Okay? And we will hear first. I understand you're splitting your time. Hearing first from
Father.
father. Attorney, is it Sullivan Puccini?
Yes.
Thank you.
May it please the court, Sharon Sullivan Puccini on behalf of Father. So I'm going to break up my argument into two sections. I'm going to deal with the adverse inference issue and then all the other factors of unfitness that we discussed in our briefs.
So just before you start that, and I know you got a plan, what do you say about the text messages
Okay.
and whether or not they may be considered, notwithstanding that they weren't considered here?
Okay, so
Because apparently they came in at trial, right?
my position on the text messages is that they were there, they're in the records. Father's attorney actually uses them in his cross-examination of the social worker on one of the days that I think probably the second day that she testified. And he uses them to say that these on it, and she says, goes through them, that's not an admission. So the position of Father's attorney was that they were not admissions.
So let's assume that reasonable minds differ as to that. We're talking about the text messages between he and his sister, right?
Absolutely, yep.
All right, go ahead.
So, but DCF's position in its brief is that their position is they don't bring up that those are admissions. Their position is that the adverse inference is a limited adverse inference. They specifically say at page 23 of their brief that the judge didn't explicitly find Father sexually abused the child. The judge only found that the mom did. Quote, nor does the court state it relied on any inferences to establish Father abused or harmed the child. Now, the child's argument is different because they argue that it was a proper adverse inference because of the admissions that you're saying in the text messages and the police reports. The child...
Well, they argue it's admission by a party opponent, and so
Right.
it comes in.
Right.
Nothing about, well, I don't know that they tie it to adverse inference. They're saying that plain language comes in. Use it for
They're
what
saying
it's
that
worth. Use it for what it's worth.
their position is that it comes in, it cites Luke. I don't think Luke Luke does not apply to police reports. Luke only applies to DCF records. But in any event, my position is that the judge did not find those text messages or anything in the police reports. He didn't make a specific finding on that.
I think that's right.
So, and this court and all appellate courts, and I'm going to cite Eleanor, you don't like to make findings. You don't want to do that.
You can't make findings.
You can't. So that is
We
what...
also don't like to, but we
You don't like to. You say that in your decisions. But child's position is that you should do that. And you can make that because it's uncontroverted, undisputed record evidence with the trial. They cite the case. It's a criminal case. But our position is you can't do that. And because it is disputed. I'm going to point you to two things that I think are relevant for you to look at when you going back and looking at this case. And that's the discussion. There's a lot of discussion because these cases take place over multiple days, months at a time, apart. And so there's a big discussion in Volume 2, 121 to 137, about Luke, about Sophie, and about the adverse inference, what they should take, if they can take it. And there's a discussion about, mom statements in the DCF records, and will it be admissible against father? And the judge says, no, they're only going to be admissible against mother. So on page of the transcripts 122, the court says, so father hasn't admitted anything, so the father would be able to assert his Fifth Amendment. So he's going on, and everyone in that courtroom is, like, no one's saying, yeah, but he has admitted. So everyone's under the assumption or under the belief that there were no admissions. That's how the case was tried. That's how everyone went about, and that's what the judge found. I mean, we hope that the judge, that's his job, to go through the records too, and make those findings. So my position is he didn't make that specific finding of any other of sexual abuse by the father. So for the adverse inference, without substantive evidence to weigh that inference, he can't make that. He can't make that negative inference without that. And DCF cites.
What's your best case for that proposition?
For the adverse inference, it would be, well, the main adverse inference case, which is custody of 2 minors.
So, hold on.
Okay.
I want to make sure that we're talking about the same thing.
Okay.
Because some of these statements, or at least the text, I'm not sure why they would require any adverse inference.
Well, he makes an adverse inference about
Who's he?
the judge.
Right, we're talking about when the Fifth Amendment, when he pleads at
Right,
trial.
right.
Right, but I'm not talking about those. I'm talking about the text where he's having a conversation back and forth with his sister about what
Yes.
he's done and about his
Right.
remorse and all these things. I'm not sure why there would be an adverse inference related to those texts. You seem to be talking about them in the adverse inference context.
Well, because for adverse inference, you have to have underlying evidence of sexual abuse. So he's taking the adverse inference that he didn't answer questions about what happened with the child with the sexual abuse. He's taking an adverse inference that he took the Fifth Amendment on that. So to be able to take an adverse inference, what's the evidence of abuse? What is he expected to rebut? And it would be that he sexually abused his child. So where in the record, or where in the case, is there evidence of the sexual abuse? I say that there's none. Child's counsel says there is. It's in the police reports. It's the text messages and admissions in police reports. I say the judge had all that. He knew about those, and he didn't make a finding about those.
He elected not to consider
He elected not to. I think they're cryptic. I don't think there are admissions in the police reports. The DCF records, there's a lot more that the mom's saying, right? She's making all these statements, but they specifically say under Luke, those don't come in.
I'm talking about the mom's statement.
Right, so it's those other things. So I say he doesn't make that finding.
But so, to be clear, the judge elected not to consider the mother's statements.
Right.
But not attribute them to the father. To
Right.
the father's conduct, rather.
Right. But there's,
But he's silent on the police reports, is what you're saying, and therefore we can't say that there's a finding made.
right, there's no finding. There's no specific finding about that. And our position is there isn't any. Like, it's too convoluted for the text messages to say that, but the position of the child is those are admissions.
So now I'm going to let you pick up where you intended to start.
Oh, well, the last point I guess I'll make on the adverse inference is to rebut what DCF is saying, that he's not making an adverse, he's like a limited adverse inference, and he's only talking about sorry.
So this is a civil case. It's permissible to make an adverse inference from him taking the Fifth, right?
Yes. Demonstrated that he never addressed the underlying issue of abuse. But in conclusion of law 22, the judge, and that conclusion of law is not cited by DCF, but that's a specific conclusion of law having to do with sexual abuse is not an essential element necessary in reaching an overall finding of current parental unfitness, but is only one subsidiary fact, and it goes on. And then he makes the finding, when confronted during trial with the allegation of sexual abuse of the child, father declined the opportunity to address the reasons why the child was removed by DCF and why he had open charges for rape, indecent assault, and battery on the child. Rather, he asserted his Fifth Amendment privilege of self-incrimination. So he's making that finding, is my position. So to go on to all the other evidence, so 'cause in the end we can say, forget the adverse inference, you know, that's, and my position is, the adverse inference, I think, is essential to his findings.
Well, I mean, he also points to his failure to comply with any of the service plans.
Right, so that's what I'm going to get into
That
next.
activity that happened post his release.
Right.
Where he didn't engage in anything until maybe after or during the trial, where he tried to go back and shore up some stuff.
So I just want to point out, too, during this, if you look at the dates, 2020, when this was taking, when the trial's taking place, and the period of time when after he's released, it's during COVID. So things are, you know, things are not normal. There's, you know, services and things like that. So there's much being said about he's refused services, but he couldn't do the services while he was incarcerated. I think that's pretty clear.
And I think they leave that alone in large part, and they talk to that, I don't know, what is it, 18 months or so?
Right, so that, if you look at that period after. So he gets released, he has a lot of restrictions on himself. GPS, can't leave the house except for legal appointments.
Does he say that COVID impacted his ability to comply with the service plan? Does he say that?
I think that's sort of implied. I mean, I think if during the trial they talk about it, or maybe because even the judge talks about, I think there's a statement by the
I'm going
judge.
to characterize that as a no. He doesn't say that.
Does he?
He say that I didn't comply with any of my service activities because of the COVID restrictions.
He doesn't use the word COVID, but it's implied because, like, for one of them, they can't go in. It's everything. A lot of things virtual, like nothing's in person. So that it was the time of COVID. So, so for one of the services, he has no internet. He has no technical capabilities, so he wouldn't be able to do do that service. And he had said that his lawyer's trying to help him, CPCS is trying to help him to get the capabilities to be able to go onto Zoom. So during that time period, he has no license, restrictions on movement, no mass health, and even the social worker numerous times says, you're not going to get any services without mass health. So he finally changes criminal lawyers, and then it's in May that his lawyer contacts the DCF person and says he's finally going to be able to get restrictions from the criminal court lifted so that he can at least get his ID, get mass health. He does get the mass health. And so then finally, 7/19/21, okay, so this is in July, the social worker makes the referrals for all these different places that they want him to do. He testifies on July 20, I think it's actually July 23rd is the date, so a few days later. And what he says is he had contacted the providers to set up the services, and in the email from the social worker, or actually he had emailed as well, if you look in the records, and I have the sites for those in the brief, these evaluations that they want him to have, the sexual abuse evaluation, the drug evaluation, batterers, the evaluations require, they're not going to take mass health, they need money. So he says, well, I'm looking for a job so that I can get the money to pay for that. So when by the time he testifies that he does have counseling set up. After his testimony, he does send a parenting plan that was not in the action plan required by DCF, but the first social worker had asked him for a plan. He finally did it, and he says that he hadn't done it because he couldn't take the child. Like, it would just be, you know, there was he had no way to even do anything. He had no contact order that he was dealing with. So the things that he did, the Nurturing Fathers group, he needed Zoom for that. You couldn't do that on phone because they had to see the person's face.
No, we're aware of the facts. You don't have to.
I don't have to go through them. Okay. So, but I think the one point that I do want to make on this, about this point, is the judge's findings. He limits, and so does DCF, they limit to his testimony. Like when he everything is like he had done, it's only like to when he testified. The trial doesn't end until like the next month, all the records. So I'd ask you to look at the last trial court reports from like the summer, and I think it's at it's in the third volume, and they start where it's, you know, even starting 3-109 to 135. Those are the court reports showing all the things he'd done and things like that.
What is the judge supposed to do with the allegation that it's sexual abuse, that the nature of this abuse, that there's a pending criminal case? We don't know how long that criminal case is going to be pending, how it's going to be resolved. At that point, he has no money, he has no, essentially homeless father at that time. What's the court supposed to do with all that? Just to look back?
That's a problem. I mean, that's a problem for defendants. I guess defendants and fathers or parents. They're getting conflicting advice from their different attorneys. So it's that Hobson's choice. Like, what do they do? You know, he denies sexual abuse. He wants to keep fighting for his child, but then he's got to, you know, then he could face, if he makes any, you know, I don't know. It's hard. So I'll rest on my brief. Thank you.
Thank you very much. Well argued. Counsel splitting their time 7.5 and 7.5?
Yes. Good morning, Your Honors. Beth Newsbaum, representing the appellee child. I want to respond to the last thing my sister said. Yes, parents can be in a difficult position where they have competing pressures, the pressures from the DCF side and then the pressures from the criminal side. But in the end, the child cannot be the person to pay the price for that. Father did have to make a choice between his constitutional right to silence and cooperating with DCF to address their extremely reasonable concerns about possible and I would say probable sexual abuse of the child that they had removed. Father made the choice to invoke his right to silence throughout the case. It's not just that he didn't engage in services, and child acknowledges that he couldn't engage in services during pretrial detention. But Father refused to discuss any of the allegations with DCF. He said he couldn't. He said his criminal attorneys wouldn't let him. And then, in fact, while he professed his willingness to engage in services, when he finally became able to, he explicitly told the social worker that he would not engage in a sexual offender evaluation until disposition of the criminal matter. That was, if any service was necessary, that was the most important one. This child was not removed because of domestic violence, even though there were legitimate concerns. This child was not removed because of father's mental health concerns, which perhaps were also a fairly large concern, but that's not why the child was removed. And the child wasn't removed because of father's drug use, which he acknowledged, prior drug use. This child was removed because of serious allegations of sexual abuse. Father did nothing to address those concerns. He didn't have a conversation, conversations with DCF, other than this statement about spicy noodles, which it was well within the judge's rights not to credit that statement. So if for no other reason, even absent father's admissions, which we maintain were in fact admissions, the court was justified in terminating father's parental rights because he never addressed DCF's legitimate concerns about this child's safety. The child was in care for almost 3 years at the close of trial. Father was unavailable at that point, as my sister has acknowledged. He had no housing. He had no housing that child could live in. He had no job. Trial was not even scheduled yet at that point. There was still a no-contact order in place by the Superior Court, so he had zero contact with the child all this time.
Father aware that mother had made admissions to the sexual abuse?
I believe so, because
And yet he was still comfortable with having the child put back?
until she had a child by another man. So that's another reason why he was neglectful insofar as he wanted to reunite with mom and he wanted custody of child to go to mom in the event it couldn't go to him. He maintained that position until mother had a child by another man. So this was further indicia of, or indication of father's indifference to child's well-being and safety. I would, Your Honors, like to address the issue of the admissions. My sister says that these admissions were cryptic. They were not. I'm not going to read them because I don't think it's befitting to read these in a court of law. However, I would ask the justices to look at Exhibit Volume 1, pages 31 to 33, 36 and 37, and then these same pages, for some reason, the same records were duplicated later. I think it was pages 78 or something like that. These are not cryptic statements. Yes, the text messages are a little bit difficult to decipher, but he also made oral statements to his sister that were very, very clear, that she repeated very clearly to the police. There were no objections to any of these statements. It doesn't matter if they come in under Luke or not. They came in unopposed. They came in unlimited. There was no motion in limine. There was no objection. So these statements should have been considered for all intents and purposes. I understand that it is outside the purview of this court to make findings, but I don't think this court need ignore this evidence that was on the record that supports the findings that the court did make. These statements that father made, these admissions, corroborate the adverse inference, which they need to be corroborated. That's what my sister has cited to, under custody of a minor. These statements corroborate them. Under Pinnell, the criminal case that I've cited to, it says that the appeals court may consider additional evidence on the record that the judge...
To the extent it's consistent with the findings and otherwise undisputed.
Yes, Your Honor. And consistent with the judges making the adverse inference, they're in lockstep. Father invoked his Fifth Amendment rights because if he spoke, it may incriminate him. He made incriminating statements to his sister, which were entered on the record unopposed. That provided the corroboration. However, if this court chooses not to accept that reasoning, there is still more than adequate reasons why this father's rights were properly terminated. If the court has no further questions, I will give the rest of the time to my sister.
Seeing none, thank you.
Thank you.
I'll hear from counsel for the department.
Good morning. Amy Moscato-Wolter for the department. Your Honors, I have to disagree with a couple things that have been said by my sisters about the department's position in their brief. And in particular...
You take the position that the judge did not make an explicit finding.
That's correct, Your Honor.
Abuse.
And in particular, when we talk about the New Bedford criminal records that did come in as exhibit number 4, there certainly were statements in that by father via text message, and I agree with my sister that they come in for all purposes. They were not objected to. They were actually admitted twice. They were admitted once in January 2020 when father stipulated to unfitness, and then they were admitted on the last day of trial When they were admitted 1 through 37, they again were admitted as exhibit number 4. At that time, no objections were made, no motions eliminated were filed. The only thing that father's attorney stated was that any hearsay statements that were made were to only come in for the truth. So no opinion statements. And these are not opinion, they come in for the truth, and they should come in for all purposes. Where we differ is that we are not requesting that any findings be made in and above what the lower court's findings have already been made. We don't think it's necessary. Even though the judge doesn't specifically make any statement or parallel to those statements, the judge's findings certainly conclude that the child was sexually assaulted. The judge's findings conclude that mother admitted to the sexual assault. And the judge's findings conclude that by father declining to even address that issue, that he is unfit, and that there's an adverse inference to that declining during testimony.
And that the court would be putting the child at grave risk to reunite with the father.
Absolutely, Your Honor, and it's the department's position that that's the most important conclusion of law that the judge cites. And it's not whether or not we need to determine that the judge made a decision on whether or not father sexually abused this child. The judge made it very clear that he felt that if this child was placed with either parent, that the child was at grievous risk of sexual abuse. And that he stated it over and over and over again. And that evidence was available to the judge, the police reports were available to the judge, and the judge declined to make a finding on that, but instead decided, look, this is a family, they were together for 15 years, the mother and the father. They had a relationship. Father was aware of the allegations. He became aware of the allegations when he was charged with the crime. He became aware of the allegations when the department first met him while he was incarcerated in November of 2018. When the social worker went over the allegations with him, he stated, these are taken out of context. They had to do with the child liking spicy noodles and mother's issues with some sexual issues that she had. So he was certainly aware. He never addressed those issues. He never went to counseling. During the duration of the case, the department kept regular contact with father. And at no time, he was aware that she was in therapy. He was aware of the allegations. He was aware that she was no longer living with him or mother. He never asked what type of therapy that she was in. He never asked, what it entailed. He never asked how I can better parent this child. And even when he testified in court and he was cross-examined by child's counsel said, would it be in the best interest of this child to place this child back with you? And father's response was that he pled the fifth on that question. He could not answer whether or not it would be in the child's best interest to be placed back with him. Your Honor, when we talk about the adverse inference, I think that it's important to note that there were ongoing open criminal charges against father in the Superior Court when the trial occurred. So when he's answering the questions about the allegations, we have what he is to rebut. And if he doesn't rebut those allegations, that's when we take the adverse inference. And that adverse inference, when he doesn't want to answer that, is part of the evidence that we use to find him unfit. Because this is different than a criminal case, where we're using the adverse inference to find that he did something. We're actually using that adverse inference as one of the elements to prove that he's unfit. So we do have some corroborating evidence. We also have as corroborating evidence that mother has said that the child was sexually abused. Now, mother said she did it as well as father, but that can be used in toto. It's not necessarily being used against father, but it can be used in a sense that he has to answer to what happened with his family. So that's where the adverse inference takes place. We have a lot of other corroborating evidence that he was also unfit, that the judge took particular care to discuss. And in the judge's findings and in his conclusions of law, and it's been stated, the judge does focus on the period of time that father was released until he testifies. During that time, he did absolutely nothing. And I know it's unfortunate. We have COVID. Father wanted a jury by 12. He was in limbo. However, we have a child that's been waiting almost 3 years for permanency. And in this court and in our cases, the child's best interest is paramount. So we need to have permanency for this child. And that's why the judge had to really make a decision. I think during testimony, father actually said, because he had no plan for the child, the father said, I need more time. And that's what he was looking for. But he had absolutely no way to provide for the child. He had no job, he had no housing, he had never been put into therapy. He had a no contact order that he had had no contact with this child. No phone calls, nothing. And in the record, it indicates that the child did not want that contact. It was not in the child's best interest to have contact or to further delay the proceedings. So, Your Honor, are there any other questions? I'm limited in time.
Seeing none, I'd like to thank counsel for all three parties. They've been well represented and the case is submitted.
Thank you, Your Honor.
Calling our final case, docket 22P 780, Verdura v. DELGROSSO. We will hear first from counsel for the appellant, Attorney Epstein.
May it please the court, I believe
Morning.
entering the courtroom will be my clients, as well as Carmela's niece, Patty Roberts, and her care manager. Looking at the facts, it is beyond doubt that Carmela and Clorinda, sisters-in-law, were close, and that despite the deed, always understood they were partners, fiduciaries in the Cleveland Street property, and that Nancy, to whom Clorinda gifted the property.
So you say that a partnership existed, right? Isn't that?
A partnership, a fiduciary relationship in the property at 4850 Cleveland Street.
You say a partnership existed. You rely on I think a 1938 case or 1941 case, Bowler.
Well, we're relying on, first of all, the agreement that the parties to the deed wrote. And that other than the deed that ultimately went between brother and sister, everybody performed, and they continued to perform after Nancy got the deed. And even after inquiry was made of the attorney who drew the deed, I got no answer.
It was a business for profit?
Was there a business for profit in the property? Yes. Clorinda was receiving rents for the first floor property.
From whom?
From a tenant.
Was she sharing those rents?
No, she was not sharing those rents. Under the agreement, the rents for the first floor apartment accrued to her benefit.
So where were the profits shared?
Pardon?
If this was a business for profit, where were the profits shared? Point to the profits that got shared amongst the parties.
Well, Carmela, after her husband died, had the benefit and the profit of having rent-free the second floor, subject to her performing her duties under the agreement.
For what? Pay the utility bills?
Pay half of the taxes, pay half of the water, pay half of the oil, pay half of any other expenses that were accrued, and she acted as the agent for both parties concerning arranging insurance, making insurance claims. While it may not speak to being a partnership in the usual sense where both parties are making cash money that they have to report as taxable income, they were in a fiduciary relationship that requires full disclosure. And when Nancy learned after the deed, I mean, No municipal lien certificate was obtained by the council who wrote the deed from Clorinda to Nancy.
Sorry, I didn't hear what you said. No what?
No municipal lien certificate was obtained. Had that municipal lien certificate been obtained, then the attorney drawing the deed would have been on notice. Hey, who's this Carmela? Why is she on the municipal lien certificate as an owner of the property? All along, after that deed that was drawn to Nancy, the tax bill got changed to include Carmela. The water bill got changed to include Carmela. Nancy was aware that Carmela is arranging for the homeowner's insurance with an ownership interest. They're stopped from denying that there's a fiduciary relationship here because they've ratified it and repeatedly ratified that there's an agreement. It was not having gotten no response from the attorney and then subsequently having learned that the attorney who drew the deed that's the real hindrance here, the deed from Clorinda to Nancy, that he arranged for that, her husband, Nancy's husband, he arranged for the attorney. They were all present during not only the conveyance of the deed from Clorinda to Nancy, they were all present when Clorinda executed her will. Her son-in-law arranged to provide the attorney with the information. One thing that her son-in-law failed to provide to that attorney was a copy of the agreement, which they admit they have, the 1997 agreement.
Your argument at the end of the day is that they should still be tenants in common, correct?
No.
Okay, what is it?
Our argument is that there's a trust here, a fiduciary relationship. It's unnecessary to reform the deed. It's necessary to settle up on the partnership. That's where it is our current relationship.
And how do you reconcile, I'm sorry to interrupt you, but how do you reconcile that argument with your statement in the letter that your understanding was that from the registry record, was that Clorinda and Benedict, as trustees of their father's irrevocable trust following their father's death, conveyed the property to themselves as joint tenants?
How do I what?
How do you reconcile that with your argument? How do you reconcile what is stated in the letter, the 2013 letter, with your argument?
I reconcile my admission in my letter that the record shows that when Benedict passed away, that based upon the deed they had executed earlier, that the record shows that they're joint tenants. But I'm calling into question in that letter
whether or not that was a Scrivener's error or inaccurate in some way.
Yes, I'm calling into question that letter.
Okay.
And I understand that
So I guess that begs the question here, right? Whether or not that is sufficient at that point to put the onus on you to file an action within, I'd say, 6 years of that date.
I'd say, and I'd return to A, the estoppel of the course of conduct, which is serious here because my client is losing a significant investment.
Yes.
B, even after they received whoever he was representing, and it's, in my opinion, that the record clearly provides a reason to believe he is representing Nancy on that transaction and not Clorinda. And that is buttressed by the fact he didn't get a municipal lien certificate. He didn't do a title examination. Information was withheld from him concerning how the property was being managed. That there's a compelling estoppel argument here that you may be able to claim the statute of limitations as to the deed, but you cannot until you rejected the partnership just before we filed suit, that we may have been aware that you could cause us harm, but you didn't cause us harm all along. You continued to perform. You continued to lead my clients to believe that they had an interest in the property. In fact, that continues. My client is receiving rents for the second floor apartment. My client is still paying half of everything. No effort was made to stop that. And as much as we were on notice of a problem with the deed, they were on notice that we were making a claim. So shouldn't they have done something prior to that performance by my client? I believe morally and ethnically and equitably, they should have brought an action within immediately when they realized that they were continuing. It's the only way that justice can be done here. The statute of limitations runs to the deed. The deed, while tangential to the contract, which is a writing, calls into question, A, why the deed ended up being contrary. B, I would note that the attorney who drew the deed to Nancy, I believe he wrote, he wrote a deed from Nancy to her child and her husband's child and to themselves, where he called them tenants in common, I believe is my memory, with or joint tenants with right of survivorship, because as conveyancing standards have changed, conveyancers are tending to be more clear. They could write a tenancy in common with right of survivorship, or make it clear that it's without survivorship, to avoid just the kind of issue that's before this court. And the unjust enrichment that appellees will obtain if this isn't sent back to the lower court for resolution of a dissolution of the partnership fiduciary relationship, because that's where equity is. And equity stands above, many times, law. Because the great and general court cannot anticipate, nor as human beings can they be expected to anticipate, every circumstance that may arise.
What is your best case to support the proposition you just made? What is your best case to support that in a context like this, that principles of equity can trump legal arguments such as the statute of limitations?
It's the case we citing for, and if you'll give me a moment, I believe it's the Sullivan and Lawless and subsequent cases, if I'm not mistaken, where brothers are partners, a deed is granted to only one of them, and yet there was at least a genuine issue of material fact as to whether that property was in the partnership because of the way they handled the income and expenses of that property. So that reformation of the deed isn't the be-all and stand-all, and that not until the partnership fiduciary relationship was rejected, in fact, it's still ongoing, was my client put on notice that more than an in-show concern that they might stand upon the deed, but that they were going to stand on the deed. That's when the injury in fact occurs. Otherwise, it's speculation. From my client's perspective, because they're performing. As if the fiduciary relationship continued to exist. That is the best case here, Your Honor, and that's why I focus on count 2. Because count 2 leads to the amended complaint, which sets forth accusations of knowing criminal activity, and certainly knowing tortious activity by Daniel. Because he arranged the whole transaction that is the problem here.
The motion to amend came after the summary
It
judgment?
came briefly after, Your Honor.
Matter that it was briefly after?
Yeah, it was briefly after, and judgment and its filing occurred more or less simultaneously. But if we're successful before this court, and we pray that we are, then we can proceed to prosecute an amended complaint, or, as it's been my hope since the start, reach a reasonable settlement.
Thank you very much. We appreciate your brief and your excellent
Thank you,
argument.
Your Honors.
Attorney Kornitsky.
Good afternoon. Mark Kornitsky for the appellees. May it please the court that the case of the brothers on the partnership is the Drinian case that is in a line of cases with the Sullivan Lawless case. The Drinian case is quite different than what we have here. In that case, there were two brothers, operated a partnership. They held bank accounts together. They filed partnership returns. The bank accounts were used for expenses and income. They purchased 6 properties together with partnership funds. The death of a partner causes the dissolution of the partnership is one of the other things in that case. Here, the death, if you were to take that argument, that at one of the partners' death, Benedict Jr., that it would have dissolved the partnership, that would have been in 1999. And what I think is important to note about this partnership argument, the people that started this partnership were Benedict Jr. and his sister, if you ought to accept that argument. And the claim that Benedict Jr.'s estate, which is not a party to this case, would have against the other partner would be against his sister, Clorinda. Clorinda died in 2017. There's a short statute of limitation against an estate of 1 year to perfect that claim. Clorinda's, so there was no action taken, but I want to bring back to the way this appeal is broken down for this court. The appeal presents arguments that the summary judgment motion should not have been allowed at the lower court. And there are 2 counts in the complaint. There's a reformation count, and then there's this fraudulent concealment count.
Yeah, it's unclear whether it's a breach of fiduciary duty or fraudulent concealment. But
right, but I'd suggest those are all sound in tort. That from the time you know, it would be 3 years. So the longest statute of limitation argument on when the clock begins to run, I'd suggest would be count 1 on the reformation.
6 years.
Would be 6 years. And the December 19, 2013 letter is clear. It says to correct the record at the registry to reflect the true state of the ownership of the property. It's a classic reformation case. In the verified complaint, it says there was a Scrivener's error. And as Judge Liu said in his memorandum of decision, the precise reason we have these statutes is because the action should be brought timely. Now what we have here, we have the 2 parties to the deed, the brother and sister, are both deceased. The notary and drafter of the deed, Philip Epstein, he is deceased. So there's no one here to testify as to what the parties intended to do with that deed, whether it was a mistake or it was not a mistake. Now, those are the factual questions.
I think that's precisely your brother's argument, is that it appeared to be a mistake, and there was ongoing fraudulent conduct.
Well, there's a 1997, in February, Benedict Sr. passes away. Same month, February 1997, the written agreement, which is Exhibit 1 to the verified complaint, states that with the two trustees of the trust, they don't sign it as trustees, but they're the two trustees of Benedict Sr.'s trust, what they're going to do with this property. One of the things is we're going to convey it to ourselves as tenants in common, and how we're going to treat the property with respect to each unit, the garage. It spells it out, but it doesn't say whether or not that's until we convey it out from the trust or continue after. What they end up doing, and the record reflects, is they end up doing what was in that February 1997 agreement. They treat it essentially the same. They share expenses, they do all that, and there's a difference in title, but there is no way for us to know if they simply didn't just change their minds as to the title. In fact, the record reflects that Clorinda believed that they both owned it. There's no dispute about that. Clorinda thinks, okay, well, essentially it must be a scrivener's. Should be, a question for reformation. But the action is never brought. It is known. The clock begins to run in 2013, and they don't bring their action timely.
Let me ask you this question. On the motion to amend that was before
Yes.
Judge Liu, what was his standard? What would be the standard that he would apply in allowing or denying that motion?
Well, on the motion to amend, which is just for the timeline on that, on June 1, 2022, Judge Liu allowed the summary judgment.
I'm aware of the timeline. My question is...
15 days later, the motion to amend. As the cases I cite in my memorandum, what we know from the record is the handwritten notation at Record Appendix 224, where it's written,
My question's a pretty straightforward one.
I'm sorry, I don't understand. If you could give it to me again.
Sure. Judge Liu had before him a motion to amend, and I'm aware of when it was filed.
Yep.
When it was put before him. What was his standard for either allowing or denying it?
Well, I'd suggest you'd have to look to you have the tracking order from this case, which is long expired. The case law that I've cited in the brief, the Audubon Hill and the Weedman, the Bradford group, those cases both talk about motions to amend after. In the Audubon Hill case, the appeals court upheld the denial of a motion to amend after a summary judgment motion was served and filed.
Was Judge Liu obligated by law to allow it, obligated by law to deny it, or did he have discretion to do one or the other, or was there some other standard for acting on the motion to amend, is my question.
Okay, I would suggest that it would be in contravention to it would be different than what any of the case law that is reported permitted, and that the rules of civil procedure did not permit it. I would say he didn't have the authority.
What rule would you cite to support what you just said? What rule, if the rules preclude him allowing it, what rule?
I would say the cases I've cited, and with respect to the rules
These are
of
not
civil
easy
procedure,
questions, by the way. I'm sorry to interrupt you. These are not easy questions. I understand that I'm asking you something that's a little bit outside of what's being argued.
I would say Rule 15 on amendment of pleadings would be...
Precludes it. affords him zero discretion to allow it, depending on, it strikes me that he has discretion depending on all of the factors. And there might be a reason, there might be a cause argument, there might be a showing of excusable neglect, there might be, I'm not sure. That's why I'm asking the question. But it strikes me that it fits somewhere under the rubric of either discretion or some other standard where it's not forbidden. That's why I'm asking you this question.
I can't sit here before you and say it's forbidden. I can't say that. I am unaware that there's case law that says Rule 15, you can't do it. I'm just saying there's no case that has done it before.
Okay.
And with respect...
So let me just get to my point.
Yes.
Judge Liu neither allowed nor denied the motion, correct?
Correct.
So we have an open motion. What he said was, no need to take action because I've already allowed summary judgment.
Right. So he treated it as moot.
I'm sorry?
So he treated it as moot, right?
He treated it as moot.
Was that error?
I'd say it's not error. The case, it should have been a Rule 60B or a reconsideration. In fact...
I'm not quite certain that it's moot. I think it's an open motion before you, but I could be wrong. We haven't made a decision yet. I'm asking.
Right. I see it that Judge Liu saw it that the case had been decided and that the motion to amend was too late. I believe he thought he did not have the ability to rule on the motion. He saw it as, I think he saw it as moot. I would say it was futile because the partnership theory and the motion to amend and the proposed amended complaint is a claim that was held by Benny Jr. and needed to be brought within a year of his sister's death. So it would be futile in any event. The partner isn't even a party to this. The purported partner, his sister, is not, she's not a party to the claim. The brother's estate is not a party to the claim. It would be futile. And quite frankly, there's no standing for the trustee of this trust to bring a breach of partnership claim.
Would you agree if this was a court of equity, you may have a very difficult road?
Do I agree that a court of equity would have a difficult road with these facts you're suggesting?
That your argument would be difficult if we were a court of equity, of equitable jurisdiction?
No, because the rule of law that the statute of limitations has run. The argument about the continuing...
It's a hypothetical. I'm putting aside the statute of limitations for a second. Just as an equitable matter, would you believe, would you agree?
I can't remember who said it about
You don't have the law, argue equity. When you don't have equity, argue...
No, that wasn't the one I was thinking of, but difficult decisions when you have a hard and fast rule like a statute of limitations can feel unfair, but it's the law. That's what it is, that you knew, you should have brought the claim. Equitably, would it be unfair now, all these years later, that all these witnesses are gone, and I'm arguing a summary judgment record. Okay, we accepted all of their facts as true. So on this record, I'm saying there may be other things that none of us will know, but it ends here because my client shouldn't be forced to litigate this case because the statute of limitations expired. And the partnership claims that are brought after summary judgment, those claims would be futile because they're misapplied here. It was for the estate of Benedict Jr. to bring against the estate of his sister.
Do you think that it was anything but a Scrivener's error that changed it from joint tenants to tenants in common?
Well, I do, but it's outside the record.
I know, but I'm just asking. As a matter of fundamental fairness, you think that was...
Yeah, that's what the evidence we expect would have been at trial, that there were reasons why it was changed.
Like?
Like the brother thought he was going to outlive his sister. He lived at the property. So he made a bad bet, and now trying to change that because it was all or nothing. But that's not in our record. What's in our record is...
They certainly didn't act that way amongst each other while he was alive, right? He
Right,
wasn't trying to one-up his sister while they were alive.
Right, but in our record, I believe in the testimony of Nancy, it discusses why when the sister discovers in 2013 that she's the sole owner of the property, she says, well, I don't want anything to happen to my sister-in-law. She can live there. We're going to continue this arrangement. So that's what happened. So she let her stay there and kept the status quo for the rest of her life because that's what she thought was fair. Now, if she was wrong, if she had some duty, those are claims that all should have been brought within 6 years. They knew it. There's no doubt they knew it.
I have one final question, and that's this. Are you saying that the motion to amend, which has not been acted on, would be futile because there could be no cause of action that wouldn't have already accrued under a statute of limitations?
Correct.
Nope. Thank you both. This is a difficult case.
Thank you very much.
The case is submitted. That concludes our session.